There is a lot of confusion around slip and fall accident in stores. People wonder whether a store is always responsible if there is a spill or a danger that causes you to fall down and get hurt. The answer is not that obvious, and when those unexpected tumbles lead to serious injuries, responsibility for unsafe conditions becomes a major legal and factual battleground. So let's get to the heart of law of store safety for customers. For a store to be held responsible for a slip and fall, 3 key things need to be proven. First, there was a dangerous condition on the property, like a spilled drink, a broken tile, or clutter in an aisle. That part is easy. Either there is a spill or something on the floor, or there isn't. The next legal point is that this dangerous thing on the ground must have created an unreasonable risk of harm. Unreasonable is in the eyes of the beholder, and it is a highly subjective factor that is decided by the jury. The question is very up in the air, because each case where a person slips and falls is different, and there is no absolute standard of what is or is not reasonable. And yes, I admit that I use the phrase up in the air as a small play on words, given the fact that slip and fall is the topic of this video. But we all know that a slip and fall injury can be very serious and life-changing. So that's the end of my digression. The second element of a slip and fall case is the issue of notice. There is liability to the store if the store either knew about this hazard or should have known about it had they been paying reasonable attention. Again, you have the word reasonable, which, as I said, is a very fluid and hard to define phrase. And third, the store failed to fix the problem, block it off, or at least warn customers about it. Now, a big piece of this puzzle is whether the store knew about the danger or should have known about the danger. If an employee saw a spill or a customer reported it, that's called actual knowledge, and it makes the store's responsibility pretty clear if they didn't act. But even if no one directly knew, the store can still be on the hook. How? Through something called constructive knowledge. That means if the hazard, like a puddle, was there long enough that a reasonable inspection would have caught it, the store should have known. California law expects stores to stay on top of things with regular checks. Here's an interesting twist. If the store's own employees caused the hazard, say, they spilled something while restocking, knowledge is automatically pinned on the store. No excuses. But how do you prove who dropped the banana on the floor and left it there? One more thing to note, the way a store operates matters. If they've got a setup that makes spills or clutter more likely, like a self-service buffet or open bins of merchandise, they might need to step up their precautions. A 2003 case, Moore Veers Walmart Stores, said this doesn't mean stores are strictly liable for every fall, but their business choices can raise the bar for what counts as reasonable care. So, what's the takeaway for store owners? Be proactive. Schedule regular inspections, train your staff to spot and fix hazards, and use signs or barriers to warn customers. Keep records of what you're doing. It could save you in court. And for customers who've been injured, if you think the store's negligence caused your fall, talk to a lawyer to see if you've got a case. A lawyer will try to get cleanup logs that show how often a store has cleaned the area where you fell. The lawyer will look for video footage and try to track down witnesses. Unlike car accidents where the police are often called, slip and fall cases are usually not documented in police reports or with police body-worn camera footage. For this reason, getting legal help quickly can be critical to your case. The law office of Daniel Horowitz is expert in slip and fall cases. Call us at 925-283-1863. We can help, and there is no fee until you recover money. Again, please call right away at 925-283-1863.
The law office of Daniel Horowitz is expert in slip and fall cases. Call us at 925-283-1863. We can help, and there is no fee until you recover money. Again, please call right away at 925-283-1863. You are entitled to the best legal representation without any fee until you recover. Again, call us at 925-283-1863. Again, that number is 925-283. Thank you for watching our video.